Hello, good evening, good afternoon. My name is Jordan Walker. I am an attorney with Seaver Walker Paget Law Firm. Thank you so much for bearing with me. We had a brief technical issue, but we are ready to get started. Thank you for taking the time this evening to join us to talk about this pipeline project. And with that being said, I will just go ahead and get started and share this presentation. Okay. So, again, my name is Jordan Walker. I am an eminent domain attorney with the law firm of Seaver Walker Paget. Today, we are here to talk about the Elba Bridge Express or the Elba Express Bridge Pipeline Project by Kinder Morgan. We are here in association with attorneys with Bannister, Wyatt, and Salvi LLC. They are South Carolina local counsel. We will be working with them on these matters, but I will be the one presenting today and talking to you about what to do when a pipeline wants your property and how to handle it and what you should do when they come knocking and start talking about acquiring your land. So, with that being said, like I said, we'll get started. Uh, Here is a list of the agenda. What we're going to talk about. We're going to talk about our firm a little bit, why we're different than other firms. We're going to talk about what eminent domain is. We're going to talk about the difference between uh, eminent domain and, excuse me, I have to make some changes on this. Eminent domain versus condemnation, and then the Elba Bridge Express project, what's coming, where we're at in the process, what to expect in these situations when a pipeline needs your land. Then we're going to talk about more granular details about your negotiations with the pipeline, specifically the easement itself, what they're going to want from you. We're going to talk about right-of-way agents, what they do, what their role is with Kinder Morgan, with the pipeline company. We'll talk about just compensation, probably the most important component uh, of this presentation is what you're entitled to under the law, and that is just compensation. And we'll talk about what to do when you get an offer and next steps and all that. We will of course be taking questions. I'd ask that you write them down, keep them in mind, and we will get to them at the end of the presentation. The reason why I say that is a lot of times we already cover a lot of the questions that folks have to ask during the presentation. So, a little bit more about our firm, Seaver Walker Paget, what we do. Again, we are eminent domain only. We are landowner only. This is the only area of law that we practice. Most attorneys that do condemnation work usually do condemnation work in addition to other areas of law, or they only represent the condemnors, or that being the folks that can take the land. We are neither of those. We are only eminent domain. It's the only area of law that we practice. If you go to our website, that's all you'll see. But beyond that, we've never represented a pipeline or a condemner, and that means the DOT, pipelines, power lines, cities, states, villages, whoever can take land, we've never represented them. We've only been landowner throughout the duration of our firm's existence. As a consequence, we've learned a lot. We've learned a lot about how these projects work, how they move, what pipelines do, their tips, their tricks, their strategies that they try to implement, incorporate into their acquisition discussions with landowners. And to that extent, like I said, we've acquired quite a bit of experience. And my job today, what I'm here to do is to relay to you what we have learned and all the knowledge we've accrued, so that when they come in, if and when Kinder Morgan comes in and starts talking to you about your property, you'll be adequately prepared. Um, let's talk about the project real quick, but I do want to actually touch on one point. Why did you receive a letter? We've gotten of the response we've got from folks that responded to our letters. Well, first of all, you got a letter because your property was identified by Kinder Morgan as potentially affected by this project. And the reason why we know that Kinder Morgan identified your property as one of those that's potentially affected is because they told FERC that. And FERC is the Federal Energy Regulatory Commission. Because this is a natural gas pipeline, and because it is an interstate natural gas pipeline, it goes into Georgia. Uh, it comes with, it's governed by FERC. It is governed by the Natural Gas Act, which is governed by FERC, which means it's federally regulated. And that means in order to build the project, Kinder Morgan needs to get FERC approval before they can do anything. And they are in the midst of doing that right now. They are in what we call the pre-filing stage of the FERC process. So to put it in layman's terms, we are at the very, very beginning of the process. And that kind of was borne out with what we saw in our responses to our letters. And that is, folks might be familiar with the project. They might be familiar with the project. But as far as I am seeing, I don't know if anyone's gotten any offers, but nobody has told us that they've gotten any offers yet from Kinder Morgan. And that's to be expected. They go at their own schedule. We can't determine that. We have no control over that. But we've found that around this time period, the pre-filing stage and into the filing stage, is when they start to reach out to landowners to contact them about making offers. So if you haven't heard from anybody, that's fine. That's to be expected. Ultimately, what I tell landowners, and one of the questions I get the most is, how do I know if I'm affected? How do I know if I'm impacted by this project? And ultimately, you can jump on the FERC website if you want. The docket number is right there on this page, the PF 25-2-000. If you want to jump in there and see if you can find the maps and see if you can find your parcel, by all means. But ultimately, you will know when they need your land because they have to reach out to you, and indeed they will. They are very present when they are ready to acquire land. So you will absolutely know. So a lot of people call me, they have no idea what's going on. They're worried they missed something. And the reality is they very likely didn't, because the pipeline is very present when they want to acquire land. Again, you will know. So if this is the first you're hearing of this project, that's fine. That's actually good because you'll be more than prepared when they reach out to you about potentially acquiring your land. Back to the project, it again is a natural gas pipeline. It is 71 miles. It goes from Georgia to deep into South Carolina. It is a 30-inch diameter pipeline, which is not the biggest, but also not the smallest by any means. They anticipate putting it into service here in about 4 years, a little over 3.5 years. And so where we're at in the process, like I said, we're at the FERC process. That needs to play out. But while it plays out, Kinder Morgan will eventually get to starting to acquire easements. And that means potentially getting it from your property. Now, where does eminent domain fall into play? Well, first, let's talk about what eminent domain is. Eminent domain is the inherent power of the government or a private entity that's been granted that power by delegation or statute to take private land and put it to a public use. Meaning, if you don't want this pipeline on your property and for whatever reason they refuse to move it, they have to get your property. They can't move it. They need your linchpin parcel, and that's that. You can't just say no forever. Eventually, they will utilize the court system, and because this is a FERC project, they will use the federal courts to acquire the land, whether you want to sell it or not. That, in a nutshell, is eminent domain. It is most commonly understood as being executed by departments of transportation, cities, towns, states. But actually, in our experience, utility eminent domain is much more common because they affect many more landowners generally, and they are always being built. So, really, eminent domain by utilities is kind of the more common of the types of eminent domain, or I guess the uses to which eminent domain is utilized as we sit here today. You might say, well, how is a pipeline a public use if they're just going to make all this money off of it? And my response is, that is the world we live in. This is natural gas pipelines. This type of infrastructure have long been determined to meet the definition of a public use. So they will be able to utilize eminent domain when it is delegated to them. Now, and another important distinction, because this is a FERC project, they do not have eminent domain until the project is approved. The project, like I said, it is currently in the pre-filing status of FERC. I believe they're filing later this year their formal application. I would expect a FERC approval next year. Now, you might ask, well, what if they reject it? If they reject it, great. Then this was all for naught. The project isn't built, and you get to keep your land. I don't expect that to happen. Not because I have specific knowledge about this project, but because, generally speaking, FERC approves these projects. Very few pipeline projects, FERC regulated pipeline projects, are canceled by FERC. I can only think of one off the top of my head. Usually, if they don't happen, it's because the pipeline themselves canceled it. If Kinder Morgan wants to build this, and I assume that they do, it is fair to assume that they will get a FERC certificate. I'm not going to say it's a rubber stamp at the FERC level, but it's pretty close. So what that means is that if they get this authority, then it doesn't matter at that point that you don't want to sell it. They will be able to use the federal courts to acquire the land. So the reason why I bring that up is not because your case is necessarily going to get to that point. And the reason why I bring it up is because pipelines, and as a matter of fact, a lot of our cases with pipelines don't reach that point. But because they have this power, or they will have this power, it changes the structure of negotiations. They have this leverage that they can wield over you if they so choose, and they generally do. So you need to even the playing field against them, demonstrate to you that, yeah, if we go to eminent domain, that's fine. I'll have my eminent domain attorney handle it at that point. And it's an easy way to demonstrate to the pipeline that you're going to be around from now and in the end. So you might as well treat you appropriately. One important part of eminent domain that I somehow have not touched on yet, and that is just compensation. So with the power to acquire land through the courts, through eminent domain, comes responsibility. And that responsibility is to pay the landowner. But it's not just pay them anything. The landowner, you, the landowner, are always entitled to just compensation. And what that means is, if you so choose, you can take your case all the way to a trial, and you can present evidence on what you feel your property is worth and what you're entitled to. And the pipeline can also do the same, but ultimately, what you're entitled to will be left in the trier of fact, or the jury, or the judge, or the commission that hears the evidence. They will determine just compensation if it gets to that point. So that's what we mean when we say just compensation. You never have to take their offer if you don't want to. You always have the option to negotiate, and you always have the option to take this case as far as you'd like to see to it that you get just compensation. You always have that right. And I want to stress that because a lot of times pipelines, when they talk about eminent domain, they talk about it in scary terms and try to scare folks into, if you go to condemnation, which by the way is eminent domain, they are used interchangeably. They'll say that if you go to eminent domain, if you go to condemnation, you'll get nothing, or you're guaranteed to get less. The reality is that they don't have the only say in eminent domain of what you're entitled to. You have a say as well, and the court that hears the case also has the ultimate say. So remember that you always have a constitutional right to just compensation. So what to expect before condemnation? This is where we're at right now. They can't just file suit right now. We are in the very beginnings of the pipeline process. You guys are well ahead of everything, very far from a courtroom by any means. We are, as I would direct your attention to the item number 3, where we are right now, and that is pre-offer. So you might see survey stakes out there. You might see that actually surveyors out there surveying property, putting stakes in the ground. That's surveying, and they might already be doing it. And I tell people, if you see survey stakes, that means that is the first physical manifestation of the acquisition. But where we are right now, as far as I understand it, offers have not been issued. I'd expect them to be issued by fall, towards the end of the year. But again, also, this is Kinder Morgan's project. They go at their schedule, they go at their pace. And they're obviously not going to tell me when they're making offers. So we'll keep our ear to the ground and continue to market to folks so that we can get our message out there to folks that we're here. And hopefully, as we do that, we'll learn more about the process and where they are at it. But this is our first marketing venture on this project. So, what do they want from you, and why does this require your attention? So, let's presume that we are at the offer stage of the process. You have received an offer from a right-of-way agent that works for Kinder Morgan. He knocked on your door and said, "Hey, I'm so and so from Kinder Morgan, and we're going to build a pipeline right out on your property. And here's the easement that we want you to sign, and we'll give you this amount of money, and that'll be that." So the easement is the most important document. It is the conveyance document. It is to put it simply, a deed. But instead of giving up the entirety of the land, which a deed generally does, you give up 100% of property when you sell your home. You sell all of it, not a portion of it. But for an easement, you're only selling a part of your land, and you're only selling the right to do certain things on that part of the land. So the easement that you will sell to them will state specifically what they can do, what you can do, what their responsibilities are, what your responsibilities are. Everything that is important or should be important should be in that document. And that will define everything. So one of the questions I get, are they allowed to do this? Are they allowed to do that? Can they install cable? Can they install fiber optic? Can they put up a transmission line? All these questions I get quite a bit. My answer to that question is it all depends on what that easement says. The easement will govern exactly their rights in that area, which is why it is absolutely imperative to make sure it is documented properly and correctly. One thing I will note is that a lot of times, what is told to you in your living room table by right-of-way folks working for pipeline companies is not necessarily what the document says. They'll come in, they'll say, "Oh, we're just here to build one pipeline for natural gas. We're going to put it right there. It's 30 inches wide. We're going to put it in, set it, forget it, never come back." The problem is that's what they'll say. Now, what the document, I haven't seen the easement that they're proposing on this project specifically yet. Pipelines vary with the type of easement they propose to folks. A lot of times, a majority of the time, the document needs a lot of work because it includes some of these things you see on your screen right here, these clauses that they sneak into the document that a landowner shouldn't be expected to read, let alone understand. For example, they will include unfettered access. So they'll say, "Oh, we'll just come in from this spot over here and that'll be it." But if you look at the document, it'll say the right to use the entirety of the land, the right to access the entirety of the land, all four corners. We see easements that require no remediation, that they'll put the pipeline in, they won't fix the ground that they disturbed, tore up, destroyed. There'll be a clause in there that says they don't need to remediate, or there'll be no clause that says they don't need to do anything. You need to make sure that that gets added. I've seen clauses that shift liability to the landowner in the event of incidents, or they make you joint and severally liable in addition to them. I've seen the right to sublease these easement rights to cable companies. That one is very common because they can put in the easement the right to build communication lines, and then 10 years later, 5 years later, go out to Verizon and say, "Hey, we got this easement. Do you want to run your cable through? Give us, whatever amount of money per foot." And then they go in and do it, and then the pipeline company gets paid for that sublease. You don't get anything, and you say, "Why?" And they say, "Because you gave us the right to sublease this to communication companies." So that's another thing they like to. They will sneak in as much as you let them. No clause that requires them to pay for future damages. No indemnity language that protects you from future incidents on the line. The right to add more lines, that's fairly common. The right to enlarge the existing line. So they'll say, "Hey, we're just putting in one 30-inch line," but it'll say the right to enlarge the pipe, which means actually you're giving them the right to build a 60-inch pipe if they want. So these are just some examples. It's imperative that you have a legal professional review these documents. We do this for free as a matter of course, because they will, if they can, they'll get away with what they can because it's a valuable document to them. So It's incumbent on the landowner to get the type of clauses that landowners need into the agreement. And one more important fact: easements are forever. So when you sell your easement or you sell your property that has this easement to somebody else, or your children inherit this property, or your grandchildren inherit it, or whatever happens, the property changes hands, that easement doesn't go away. It stays with the land. So the new owner takes the property subject to the easement. Your children take the land subject to the easement. And if it was poorly drafted and includes poor language, like I just talked about, then it's going to continue to have poor language. And the burden that the easement has now will burden your kids down the road when they're owning the property. And Kinder Morgan wants to come back in for whatever purpose and without further compensation to them. So easements are forever. They always stay on the title, barring some sort of clause that requires their removal. And because of that, it is, if for no other reason, for folks, getting the easement proper is, for a lot of people, the most important thing, because again, it's forever and it doesn't necessarily affect them. It's going to affect their kin, whoever's inheriting the property. So that's the first part of it, language. And then the second part of it, money. So there's two components to every acquisition: language and money, the easement and what you're getting paid. Our firm does both as part of our representation. Our representation has one fee. We handle everything. So we'll get into that in a little bit, but it is imperative, of course, to remember that you are entitled to just compensation, fair compensation. So the way fair market value, or what you're entitled to, is determined under the law. You're entitled to basically a before and after view of the property. What was the property worth before the pipeline? What was the property worth after the pipeline? The difference between the two is what you're entitled to, plus the land that they're acquiring. Now, and the important takeaway from that is that it's not necessarily just about what they're taking, it's about what they're leaving behind. In a pipeline easement that runs diagonal through a farm or diagonal through a property, might have a huge impact not only on the area that it's affecting, but all four corners of the property. That property that didn't have a pipeline before now has one. So how does the market respond to a pipeline, a property with a pipeline on it? And depending on, if you ask Kinder Morgan, there is no impact. If you ask me, there's a big one. And that is something that they do not do a very good job of offering landowners. It's called remainder damage. You can call it diminution in value, consequential damages. They all mean the same thing. And that is, how does the pipeline affect the rest of the parcel? It is something that energy companies and DOTs do a terrible job of across the board. And it's something that you'll have to fight for. Crop and land damages, that's another part of it. If they're going through crops, if they're going through timber, you need to get paid for that. Also, you need to make sure that you get either proper restoration language in there. And if they don't, you need to make sure you get paid for any damage they do during construction. Finally, on this note, just remember, it's all about leverage. Your ability to say no to Kinder Morgan when they roll up and give you their offer is where you get your power, where you get your strength. Talking to an attorney is where you get leverage. Employing an eminent domain attorney that they're going to have to deal with is how you get leverage. Demonstrating that you're not just some landowner who's going to take what's offered to them and you're going to fight for what you're entitled to. That's how you get leverage. Otherwise, they will run over you. They'll treat you all the same. They'll do you no favors, and you might be left in a bad spot. So I want to talk about right-of-way agents. We'll talk about the next thing, what to do when you get an offer, and then we'll end with affording an attorney if that's something you're interested in. So right-of-way agents are going to be the front line of who you're dealing with the pipeline. These are contractors that are hired by the pipeline, and their job is to sell you on the idea of you selling them your land. They are salespeople. They do this all the time. I guarantee the person you're talking to has probably had dozens, if not hundreds, if not thousands of parcels that they've had to wrap up and acquire for pipelines or DOTs or utility companies. So they have all sorts of strategies. They have all sorts of experience in talking to landowners. They've developed strategies, all sorts of things to try to get landowners to sell them their land. And to be honest, they are effective at it. And that's one thing that we try to get out in front of is to let people know that you don't need to take what they say at face value. You can get a second opinion. Frankly, if it were up to me, I wouldn't talk to them at all. And if I did talk to them, it would be via email only. And we'll talk about that in the next slide. But here are some tactics we've seen from right-of-way agents, some things to look out for. They will offer, we've seen them offer what they term 125 or 150 or what some percentage of fair market value in excess of 100% to make it seem like they're giving you a good deal. This is something, again, to distract your focus from the bigger issues, the bigger dollar figure issues that require compensation. Um, timber and crop damage, we talked about that. Sometimes they'll offer them, sometimes they won't. But when they offer them, they'll make it seem like they're doing you a favor, even though they have to pay you for them anyway. Lowering and raising offers. That's also a big thing. Manufacturing leverage, putting deadlines out there. They love to have deadlines. Some are real, some aren't. It's important to recognize when they're real and when they aren't. But they'll say, hey, if you don't take it, it's going down, or if you take it, you'll get this. These are all This is a strategy they implement, again, to make a quick decision. Quick decisions are usually poor ones in these situations. Generally speaking, if you're taking the first offer from that right-of-way agent, you're probably not doing a good job. Bonus payments is another thing they will add to offers, a marginal increase to get you to sign. Again, it'll be a nominal sum, $2,500, $5,000, to get you to not think twice about it and sign the document. That's something we see quite a bit. Verbal promises. Verbal promises mean nothing in a land transaction. All that matters is what the document says. And if it doesn't say it, doesn't matter. It has no impact. What they told you at your kitchen table in 2026 has no bearing on what they do on the land in 2035. It needs to be in the easement document if you want it protected. And then a shell game. This is something we see a lot where they distract the attention of folks with something, a low dollar, I guess, category. An example would be talking about price per acre, quibbling over price per acre when you should be talking about remainder damage. They'd love to have a conversation with you about a 2-acre easement, discussing the difference between a $15,000 an acre land versus $16,000 an acre land, because it doesn't result in a lot of money either way. So the more you're quibbling over price per acre on a relatively small acquisition, the less you're dealing with the high dollar figure, the remainder damages, the crop damages, the other assorted damages that come with these types of acquisitions. And then these are some do's and don'ts in this situation. Things that we've found helpful for landowners. First of all, insist all communications go through email. Keep a paper trail. If they want to give you an offer, if they want to make a promise, if they want to covenant to something, have them put it in writing, have them email it to you. When they want to give you the offer, say, I'd like it via email. Email is the preferred method of communication, so you create a nice record of everything that they've said, promised, and done. When they say they want to make an offer, say send it via email. If they send it via email, you respond with thank you, I'll review and get back to you. This shows that you're taking the offer serious, you're not putting them off, but you're also giving yourself a little space to do your due diligence and respond at your pace. Contacting an experienced eminent domain attorney is very helpful. Talking to your neighbors, forming a group, if you can do that, that's helpful. Group leverage can move your resolution. Read everything, read the entire document, read the easement, and then save everything they send. Keep a folder, get a folder right now, just a manila, and throw everything you get from the pipeline in that manila so that you have something. If you ever need to hand your materials to an attorney to review, you have it handy. But also, if you do the email method and you have them send everything via email, you can just shift that off to me, send it off to me or another attorney for their review. makes it very easy for everyone to review the offer and evaluate and see if it's a good deal or not. What not to do. Don't start talking about value. Don't hire an appraiser. Don't start throwing numbers out when they start wanting to negotiate because they write all the stuff you say down. These right-of-way agents will keep contemporaneous notes of their meetings with you. They'll say that landowner A said they would take $20,000. They'll write it all down, or they threw this number out. That will stick with you the rest of the case. And for the rest of the case, they'll know what you would have taken, or they'll know that you said you think the property is worth X when you might have been wrong and you might actually be entitled to Y. So, if you're going to engage in negotiations, first of all, I'd recommend getting an attorney. Second of all, I would not discuss value in writing if you are going to have your negotiations without an attorney. I wouldn't say what you think the value of the property is worth. I'll say that. Um, you don't need to hire an appraiser, generally speaking. I don't. Appraisers are expensive. Eminent domain appraisers are even more expensive. You don't necessarily always need one. We get a lot of our cases done without getting appraising so that it saves money for our folks. Don't sign anything because you feel pressured by a deadline. Don't take agents' verbal promises at face value. Don't meet the right-of-way agent in person. Keep it written. These all kind of deal with the way to handle your negotiations with the pipeline company. Um, a good way to skip past all of this, I would say, would be to just hire an attorney, and you avoid a lot of the pitfalls that landowners can fall into by self-helping, by jumping into negotiations, getting appraising, not knowing what you're entitled to, potentially lowballing yourself. All of these things. So, just some things to consider when they get into negotiations. Now, I'm almost to the end of this presentation. We'll open up for questions after this. Um, this is just how our firm works. There are three general ways that firms work. Hourly rate, deposit. We work on a contingent, or retainer is referred to as. We work on a contingency, and we only get paid if we get more than what is offered by the pipeline. If you come to me with a $10,000 offer and you hire me and I get you $40,000, we collect a third of the 30 that we add to the case, and you would get the rest. So we collect one third of any amounts recovered over and above the offer by the pipeline company. And that includes the easement negotiations. So our representation is twofold. We handle negotiation of compensation. We handle the negotiation of the easement language as well. We like doing it this way because a lot of folks don't want to come out of pocket to hire counsel, and this is a way to do that without coming out of pocket. You do not need to send me money to hire me. It's as simple as just signing a contract. So that is the way we work. And moving to my final slide before we open to questions, the day you get the offer is the day you should hire a counsel. Start talking to your neighbors. If you can form a group, great. It's not necessary, but I think it is beneficial to landowners. As soon as you get your offer, just send it to me. My email is down here. That's my phone number as well. You don't even need to tell us that you're sending it. You can just go ahead and send me the offer, and I will review it for free. You will not receive a bill from us. We do not work that way. We only get paid A, if you hire us, and B, if we get you more money. So as soon as you get the offer, just go ahead and send it. I get them every day. I'll know what it is. If I need more information, I can reach out at that point. So with that being said, I am going to open this up for questions. This is our toll-free number. This is my email address. This is our local. It's not very local, obviously. It's the Georgia area code. But that's also my direct number too if you need to reach me. So with that being said, I'm going to go ahead and open it up for questions. And if you do have questions, you can put them in the chat. Okay, I'm not seeing any questions. Give it a little more time and then we can wrap it up. I will say if you do have a question that you didn't think of, um, don't hesitate to shoot me an email. You're not going to get a bill for sending me a question. I'm happy to answer questions you guys might have. So just shoot me an email if you think of it later. If you just want to ask, a question that you forgot or it was more personal, that's fine. Again, my email is jordan@swp-legal.com. The question was, can you review how you are compensated again? Sure. I'll go back to that slide real quick. So here are the ways you're compensated. The easiest way to conceptualize it is to basically say what you're entitled to the value, the difference between your property's value before the pipeline was installed and after it was installed. And plus, of course, the easement area that they need. So if they need 2 acres of permanent easement, you're entitled to the value of the 2 acres. And if they need temporary easement, you're entitled to the value of that area on a per acre basis. But beyond that, you're also entitled to any impact or damages that that pipeline causes outside of the easement area. For example, if the pipeline is going to be within 100 feet of your house, an argument can be made that that house is going to lose value because it's close to the pipeline. That would be an example of remainder damage. That would be an example of, okay, this property was worth $600,000 before it had the pipeline in. The pipeline was installed. It was put right next to the house. People are less likely to buy the home, so the home loses value. So now the property is worth $400,000. In that scenario, you'd be entitled to $200,000. Um, Very easy, very straightforward. Uh, that's one example of remainder damage, but remainder damage comes in many different types, virtually endless, because property is unique. Every property is different, and how these easements, these pipelines can affect properties in endless number of ways that I can't. It just depends on what's on the property as we sit here. So there's a lot. That's a big part of it. The crop and the land damages are also a part of it as well. That's timber as well, crop, land, timber, anything that's growing in the ground. You're entitled to any, if they knock over your crops, they have to pay you for it. If they knock down your timber, they have to pay you for it. If they tear up your land and they leave ruts and leave ponding in the property and the easement requires them to pay for those damages, you can either get paid at the beginning based on what you expect to happen, or you can get paid after the damage has occurred. And I don't want to make it seem like this is an extensive list. Most compensation falls underneath these categories. That being, the value of the land, the impact on the remainder, and any damages that might occur. So this is what you're entitled to, and when they make you the offer, they'll probably assign some compensation to categories that we talked about. For example, you'll probably have an offer for the underlying acreage that they need. They may offer crop damages. They may offer a bonus payment on top of that. We'll see when they make the offers what they're doing. Other questions? Okay. I don't see any other questions, so we are going to go ahead and call it a night. Thank you for stopping by. If you have questions, feel free to reach out to me. Shoot me an email. I'm happy to answer them. Otherwise, thanks for stopping by and have a good night.